Good afternoon. Notice I have a new mic. Like, subscribe, not legal advice. Please send millions of dollars if you so choose. I will accept it, but no obligation. But most importantly, remember, watch this with your dogs. They really enjoy these videos. And speaking of that, a dung beetle walks into a bar and says, "Is this stool taken?" Today we're going to talk about Alpine, GTII, Finra, and the SEC, and how disgusting they all are. A recap about Alpine. Remember, Alpine was basically the shorter, or facilitated the shorting of GTII, apparently naked shorting, millions of shares. At the MMTLP crowd is certainly familiar with that. And Finra is trying to get rid of Alpine. It went up on appeal. Alpine obtained an injunction from a 3-judge appellate panel. Finra is now trying to get the full appellate panel to consider the injunction and to let them go forward to get rid of Alpine in an expeditious manner. Even though Finra could go into federal court and seek the same relief, imposing a receiver, etc., based upon all those violations. But they have elected not to do that, despite the fact I've been screaming for it now. But anyway, so that's the situation. So there's an appellate court that's deciding whether to give Finra the ability to kick out Alpine at this stage, or whether they have to go through federal court. And Finra's being dogmatic and not doing that. So because of all that, because I'm interested with little JR, Tiny JR, who's I think on a vacation this week, we're kind of just looking for ways and theories that we might be able to throw at for others and for ourselves to attack the short sellers. That applies and arises from MMTLP, for example. So I found something about Alpine that I found really interesting, and it'll let you know, again, the scumbags that we're dealing with here, really, the extent. So October 2022, there's a denial of an application to add a new representative, basically an owner representative of Alpine, and it's denied. And the application was made originally in February of 2019. There was a hearing February of 2022, denied October 2022. The application was made by Finra to add a representative, and the person who had made the request, his name was Michael Iverson. And amongst other things, and the primary reason it was denied is because he was deemed disqualified. And I'll get into what that means, because it'll give you an understanding of the type of people we are dealing with. And my understanding is that Mr. Iverson was with Alpine from about 2015 through at least October of 2022, was in the compliance department, had some type of legal background, was working with regulators. I don't know what he was doing, honestly, in light of what the accusations are as to the conduct of Alpine. It clearly doesn't seem to be acting in good faith, but I don't know. I don't know that for a fact. So again, he was in the compliance department, and it was his job basically to make sure everything was handled in a kosher fashion, properly, no funny stuff. Maybe there was a request by Alpine to bring him in because they needed his background, they needed someone to deal with all the compliance and regulatory issues, or perhaps they wanted somebody to commit crimes, or perhaps it's both. I'm just kind of partly kidding, but that's kind of what went on. So there's disqualification, obviously, and it just proves, and it'll show you why, that as big as scumbags as you thought Alpine was, they're bigger scumbags. But you have to remember, at the same time, with all this nonsense going on, we have the SEC and Finra that are letting everything going on. They're not just letting things going on, but they're blocking access to investigations. For example, there was some type of FOIA request, a denial, and then a quick denial of an appeal as to requests for 69 examinations that the SEC did of Finra between 2018 and 2020, and all the detail of the investigations. They restricted that, so they wouldn't release the information. They wouldn't tell us what actually occurred. And this is all matters. This is not just GTII, MMTLP. This is 69 different investigations over that period of time. We don't know how many occurred afterwards also, but they are withholding that information. So leaving, in effect, retail out to dry. I mean, all investors out to dry with no really good reason to do that. So recall, I find this interesting, and this is kind of part of the problem. So we have in April of 2022, we have a cease and desist order. We have 35,000 violations. April 2023, Finra finally gets involved and tries to get rid of Alpine. But what happened in that year time with all the violations? And is that all that happened? I mean, were they completely clean prior to that and there was no reason to act? Or was there? And if there was so, you knew, because this application was denied October 2022, and to deny the application, you had to do a full background review of not only the applicant, but the company. So it wasn't just the 35,000 violations, but October 2022, you had done a full background, and you still did nothing. Again, until April of 2023, when you first started taking action. And as of this point in time, you have not gone into federal court like you can to take the same kind of action. But anyway, so those are my side concerns. And we know that the SEC must have detail as to all this stuff because they did the 39 investigations. Why is the SEC shielding Finra? What's the reason? Why put the public further at risk for further Finra misconduct? We have no reason to believe that Finra has corrected any of the misconduct or that the SEC has enforced any of that. So, okay, so that's the side issue. Important to keep that on the side. So we go back to the application that was ruled on in October of 2022. And this is the data that'll make you jump out of your skin. Between 1984 and the current time, on 40 different occasions, the SEC and FINRA penalized Alpine. Now, it wasn't just money. I think there's something on the order of $14 million in fines, but 40 different occasions. That doesn't mean like 40 violations. That means, for example, on October 2022, Alpine was found to have committed or agreed that they committed X violation. On January 2023, Alpine X. So that's literally over 40 different times prior to April of 2022, where the cease and desist order was issued, prior to their denial of that application, prior to April of 2023 when they took action. There was 40 different, not accusations, but in essence convictions. Most of them were Alpine admitting to the liability, and they included, because it's a laundry list and really interesting laundry list, they include improper auditing, overcharging, failures to deliver, improper accounting, inadequate supervision, misappropriation of monies, lack of proper filings, the improper removal of red flags, engaging in false bidding practices, selling unregistered securities, breaches of warning letters, reporting problems, and not adhering to reg show and shorting. That's just a partial list of the violations that were on record involving Alpine before April 2022 and before the 35,000 violations. And the SEC and FINRA still let them operate. That is disgusting. And all this occurred before the 10/2022 denial of the application. And yet the SEC and FINRA let retail die. So besides the lack of qualification, and I'm about to hit the punchline with the qualification, besides the lack of qualification, the application that Alpine had submitted that was ruled on in October 2022 was denied because it was seen there was no public benefit. There was an inability to supervise the applicant, And in fact, the first person who was supposed to supervise, maybe more than one person in the application, had been fired from the company, just ironically. And it was a new supervisor. I think Mr. Fox was the new supervisor. So the problem was a lack of supervision, inability to supervise, no public benefit, and a checkered record of Alpine with all the violations. That was cited as secondary reasons for denying the application. So what was the non-compliance issue? So this is the guy who had worked at Alpine since 2015 through at least October of 2022, maybe till today. He was the guy they wanted to make part of the firm, be in charge of compliance, deal with the regulators, and be, in essence, the face of the company. So in 2016, he had basically attempted to molest a underage girl in a movie theater on multiple occasions while her father sat next to her. Upon the young girl yelling, M.I., Mr. Iverson, was arrested. And in 2017, that's 2017. We're talking about in 2022, they were still trying to have him as a member of Alpine. 5 years later, he pled guilty to lewd and lascivious conduct, a felony on a minor. He got a deferred entry of judgment, which means, in effect, they withheld the judgment while he was on probation. So he got a sweetheart deal, I don't know how that worked out, to his guilty plea, and he's on probation for 6 years, which I think ends in November 2023. God help us that this guy's on the street. And this guy's been working with the consent and at the direction of Alpine since 2015. You know, this is a guy who they knew was a scumbag, sleazeball, and they want him to be a face of their firm. Just imagine what kind of scumbags Alpine are. Based on what they admitted to doing in the past, are accused of doing now, and are welcoming into their midst a convicted, admitted sex offender. So, besides Alpine being untrustworthy thieves, in my opinion, no one should be surprised that not long after he admitted to being a felon, that Alpine sought to make him really the firm. But where's Finra and where's the SEC? Really, I mean, this is just absurd. So I give it a little thought. Have a great day. I was really disturbed by this report, and I can't believe Alpine, the extent of Alpine's corruption, lack of morality, and again, Finra and the SEC just sitting on their hands, letting things happen to consumers and investors and not acting in a competent, timely, or reasonable fashion. It's got to stop. Have a great day.